Hello, everyone, and guests, and welcome to Pro Bono Partnership of Atlanta webinar on issues in working overseas for U.S. charities. My name is Aaron Lewis. I'm the Deputy General Counsel International for Habitat for Humanity International. A little bit about myself. I've been working for Habitat for 20 years. Actually, was raised in the hometown where Habitat was founded, and so had maybe a family connection with the organization. So in my line of work, I've worked up about 50-50 in both domestic and foreign projects, and I was asked by Lori to come here to speak with you about the sort of various pitfalls and issues that might arise when you're doing projects overseas. We'd like to remind you that this is brought to you by the Pro Bono Partnership of Atlanta and the mission to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. And the next slide is the basic requirements to be eligible for the Pro Bono Partnership of Atlanta. I won't read through every single bullet point, but there they are for your reference. And also to remind you that there are free webinars every month. And as always, just sort of the disclaimer legal information page, which is that this webinar presents general guidelines and for Georgia nonprofits and shouldn't be construed as legal advice. Always consult an attorney to address your particular situation. And with that, we might start. And actually, it's a good segue in that, I was asked to put together sort of a presentation, which is at a fairly high level, but enough to give you a checklist or a roadmap to the types of issues that might arise in the international context when you're working, when you're furthering your mission overseas. And as such, it's sort of meant to be a checklist so that you know when to consult your attorney. So it's not going to be really legal advice anyway, as you'll see. Moving to just the overview of the presentation. We're going to focus a lot on the type of presence overseas. And before we get to that, however, we're going to talk about things that you should just keep in mind as overarching concepts. One of those is where your money comes from. The second is where your goal, what are your goals and what sort of operations will be necessary to do overseas. Then we'll move on to the country presence options that you might be able to select from. Talk a little bit about the different types of liability, and then specifically about moving money into and out of a country, which can be very technically complicated. So again, we're not going to do a deep dive into the specifics of that, but we'll certainly hopefully give you a roadmap that allows you to know when to pick up the phone and call your attorney to discuss these issues. So I think the first thing that anyone wants to think about before they think about setting up some sort of entity or setting up some sort of project overseas is, where does your money come from? The revenue source is going to affect your decision in terms of what type of entity you use, local employees versus expatriates, how to control the flow of money into the country that you're working. And I've created this sort of list of the different donors that you might have. You have the U.S. government grant, which sort of falls at the very top in terms of complexity. And when you're working in that context, then you really want to get expert advice, not just legal advice, but accounting advice, because there's a great deal of requirements, and they can be very complicated. Right below that are multilateral grants, and some might argue that some of these are as complicated as a U.S. government grant. This might be United Nations. There's Inter-American Development Bank, which is, I think, based in New York City, which handles a lot of Latin American grants. You also have foundations, which are a little less complicated, but still have their sets of requirements, and often can be onerous. Private donations from possibly high net worth givers. Again, they're probably looking for some sort of beneficial tax treatment, but they're also looking for complicated reports, small sum giving, and just your general revenue. At the very bottom, of course, you don't have to worry too much about what the donor is going to require of you, but you still have basic 501c3 regulations that you have to comply with. The second thing that you might want to consider is what you actually need to do in the foreign country now that you've established where your funding source is from and what requirements are already sort of fallen into place. You have to figure out what you're actually going to do. Are you going to hire employees there, which raises a whole a level of complexities. Uh, Not the least of which is getting a local employer, whether that's a local entity that you operate or whether that's some sort of professional employer organization, which we can talk about a little bit later. Are you going to fundraise within the country? You've probably already gotten a 501c3 status, and you're probably already qualified to fundraise and give tax receipts in the United States. Is this something you're going to need to do locally? Are you going to need to be able to receive funds and hold assets? Either these sometimes get very specific, give rise to very specific requirements, and you have to work with local governments to get the right approvals for those. So those are the first sort of very high level things that you do. Is where's your money coming from? What do you have to do? Pretty basic, but it's nice to break them down into these bullet points and sort of check the list and write you can create your own sort of grid or business plan that for project implementation plan that will have these types of columns or rows in it that you can fill out. Moving on to more things that you might need to do in the foreign country, getting into even more interactive things that have you interacting with the marketplace in that local country. Are you providing goods or services in the country? Are you signing binding contracts in the country? Are you providing grants to local recipients? Are you making loans and collecting repayments? This could actually get very complicated and require other types of registrations, subject you to different laws. It's something that I don't know how often it comes up with the group I'm talking to, but if you do plan to get into that sector, it can be quite complicated, and you want both U.S. and local advice. An interesting thing that happens, especially when you set up a separate entity that you want to govern, or at least want to have some participation in, is that you might have members of your own organization here in the U.S. serving on the board locally. That comes up sometimes. There are complications that arise from that. That's something that you want to talk to both local and U.S. I guess I should say domestic and foreign attorneys about. So, I just want to remind people that if you do have questions, feel free to interrupt me, and I'll try my best to answer them in the course of the presentation. Also, the end is just fine as well. Let's talk about a little bit about the options that you might have for country presence, because there's several. The first and sort of most labor intensive is to set up a separate organization, and you're going to govern that organization, and that's got certain benefits, but it also has certain costs. A probably less labor intensive, but what offers you less less opportunities is setting up a branch office. Keeping in mind that this can be called different things in different countries. Sometimes a liaison office or a representative office, depending on your country, or form a relationship with another entity. And there might be other options, but in terms of operating in a legal context within the country, these are your main three. There are there are visa restrictions in terms of sending people on long-term basis to countries. A tourist visa is the easiest way to get into a country, and it offers you the ability to work there for a very short period of time, as long as you're not conducting any sort of business. And of course, that definition changes from country to country in each immigration office. So that really isn't much of an opportunity. That's not really much of an option for you. There's the business visitor visa that you might be able to get into a country, that allows you to stay there longer. Again, it gets complicated because you're very limited in what you can actually do, and eventually you'll have to leave or renew the visa. So, those might come up or be thrown out as options sometimes, but I really think these three are the most serious options if you're going to do a project of any sort of magnitude. So, going down into each of the various types of options, I've organized these from sort of I started with branches, and branches are something that Habitat uses. I think we have about a dozen of them throughout the world. They're good in the sense that you're interacting directly with the country's government, so you have some say in sort of how how your organization is set up and operated in the country. They are good in the sense that you have control. You have this presence is yours. It's not a separate entity that you might have some partial governance over. It's not a local entity that you only have really a contractual relationship with. There's a very high level of transparency, or there can be, which I'm going to get into. Again, you can tailor the permission that you're getting from the local government to your specific project, which is sometimes useful. And sometimes you can hire local staff, and it depends on the registration you get. So you have to be careful when you're looking at this option to get a branch is kind of an all-encompassing term. You might have actually several different types of registrations that you could do that give you both long-term operating rights, short-term operating rights, the ability to hire employees. Sometimes you're just there communicating and developing relationships, and can actually enter into contracts or receive local revenue, and can only receive revenue from outside the country. So that's what we're really talking about when we're looking at this concerns column, is that you have these limitations on their permissible operations. You have limited local leadership, and what I mean by local leadership is, often especially in the humanitarian world, we're looking to empower people, teach people to fish, not just give them the fish, and empowering local leadership to run their own affairs to some extent is part of our mission, and it's how you provide sustainable assistance to people in need. If you just go in there and give them, short-term charitable aid, that's fine and laudable, but again, maybe we can do more. So that's a disadvantage to the branch. It's just you. It's under your control. You're not really giving any local people a voice in what your operations are. The scope of your MOU with the government may be limited. So, in some senses, you know exactly what you're able to do under the rules of the MOU with your local government, but that's all you can do. So, with clarity comes limitation. So, while you know exactly, there's no gray areas to play with, but so you can't, sometimes with a local organization as a long-term relationship, which we'll get into the next slide, you actually have the opportunity to branch off into other operations as they appear. With a branch, you may be very limited to what you're able to do, which is your original agreement with the local government. There's no liability shield. So, this is, we're delving into a legal issue here where, if one company sets up another company, then in theory, the parent company will be shielded from the liability of the subsidiary company, the company it creates. However, there are certain rules that have to be followed to get that immunity, and of course, those rules are not only the U.S. rules but the local rules in the country that you're operating. So you've got these sort of two bodies of law that makes it more complicated to understand whether you have a liability shield. With a branch, there's really none. It's you registering with the local government, and so you're really never going to have that option. And you'll still probably need to work through local charities. You're probably not going to get the rights to fundraise. You might be able to have employees. Your operations will be very limited. But at least you can have a fairly quick and easy presence. Depending on the country, there are some countries that are very bureaucratic, but a quick and easy presence in the country to start working with other entities. So that's the branch operations. The problems I've seen just historically and in my experience with branch operations is that we treat them like separate entities, or we sometimes give them enough authority to govern themselves, not realizing that it's really just an extension of our organization here in the United States. So what it does, we do. That's how you have to think about it. And it really requires a certain amount of oversight that isn't necessarily required in the other types of options that we're going to look at. So again, the problems that I've seen are people who forget that the basic concept that what it does, you do. You're held responsible for its actions. So its liability is yours. If it gets into trouble, you're the one that's in trouble, not it's not some separate organization overseas. It's you. So that's the important concept with branches. They require certain. They're great in that you can control them very easily, but they do require that particular oversight to actually control them. Moving on to separate organizations, looking at the benefits column, we're moving away from branches, which was most control, to separate organizations, which is a little less control. But as we'll see, that may have some benefits. One of the benefits is that it can still be mission aligned. You have, if it's a company that you're setting up, the ability to determine the purposes of that company in its organizational documents. It's a little more self-reliant than the branch. So we just talked about the sort of dire warnings about how the branch is there's no shield at all. There could be a shield if it's separately governed and autonomous, and you have a certain say in its operation, but not control over that operation. So you can set up or organization with a certain amount of self-reliance. You can have a local leadership. This is where you actually get local board members who actually can tell you with the voice of the community like what's going on and what's needed. So we're not coming in and sort of giving them what we think is right, but what in fact what they really need. So as the community development aspect of it is very strong in this. It also provides you with a long-term presence. If you set up a local company, and whether it's a corporation or a foundation or a trust, they have a long, it's not a project-to-project registration, which a branch might be. You can have long-term branches too. Having said that. It costs more and takes more time to set up. Moving to the concerns column, you've got to maintain it, which means you've got to either pay for somebody locally to deal with tax issues and annual registrations. You can try to do that from the U.S., but that's hard. You've got to deal with labor and employment laws if you're hiring local staff. You've got to remember it's not a branch with a board. It's its own separate company. You can have a majority control of the board. You can put measures in place to actually control this organization from, where it's almost, indistinguishable from a branch to where it's almost completely autonomous, where you only have one voting member on the board, for example, or you have a few veto rights. And so this is why it's important to talk to your attorney in planning the structure of this type of organization or presence in a foreign country, because the options are vast. You could go from almost total control to almost no control, and everywhere in between. And all of it has advantages and disadvantages according to, again, where you're getting the money from and, what you're actually trying to do in country. So that it ties back into that. With Habitat, just as an example, this is probably our favorite type of country presence strategy. It's not honestly, it's not. I don't think it's a lot of NGOs do it this way. They probably would stick with branches or work with local partners. We did this from years ago when we first started as because we really we wanted to be a grassroots organization and we wanted to be a movement with lots of local ownership. Of course, over the years, then that means I've had no shortage of work to do, just sort of managing the different separate entities. But it's a model that you can think about. Go ahead. Yes.
You mentioned labor and employment laws as work separate organizations. The question is whether employees of branches fall under U.S. or local HR regulations.
Yes. So the question is that I talked about labor and employment laws, and going back to branches, whether or not they fell under U.S. or local laws. And the answer is, well, they fall under at least one of them, sometimes both. If you are a U.S. employer, which is what everybody on this call is most likely, you'll have a U.S. employee going over there working overseas. So it's definitely U.S. law that applies. Having said that, local courts might consider the fact that because you've been working in their jurisdiction for a certain period of time and you have a certain presence there, that local rules do apply. And this gets even more complicated when you hire a employee from a different country than the U.S. So, ostensibly they're working for you, the U.S. company, but they're really an expat, and then they're working in a different country. And so we do have situations like that, and that's where you have to look very closely at the local law to see to what extent they're going to consider somebody a local employee. If you hire them locally, you can try to make the argument that they're a U.S. employee because it's a branch office and they really work for the U.S. company. But it's very likely that a local court or a local labor board will say, no, this is one of our residents. Our laws apply, whether you're a U.S. employer or not. So that is certainly a possibility that you face when you're using a branch office. Hopefully that answers the question. One very good opportunity to pick up your phone and call a lawyer, and in fact, this is where you also have to start thinking about sourcing local attorneys and how to vet and hire them. So we hit almost all of the points on separate organizations, except for this last bullet point, which is joint governance is complicated. So Habitat, World Vision, and many other international NGOs have models in which there's participation by the headquarters on local boards. And we get into any number of sort of legal issues with that. You have conflicts of interest. If you're working for one company, excuse me, and you sit on the board of another company, and that company is responsible or accountable to the parent company, then there are issues where where you might have divergent interests as a board member. So you're a fiduciary. You're to some extent financially responsible for the well-being of this local company that's just been set up. At the same time, you might be an officer of your headquarters in the United States. So if there's some sort of crisis, if there's some sort of disagreement, which side do you fall down on? The answer to that is not always clear. It depends on a lot of different factors, and it's another 30 minutes to hour webinar possibly. But it's certainly something that you need to be cognizant of. The problems don't happen often, but when they do happen, it's a real issue, and it's a burden on the individual too who has to serve. It's not just your organization, but whoever you sort of tapped for that job. The third option we have is the one that sort of represents least control, most autonomy in terms of how much control you retain in the United States, and it's working with a local partner. This offers you the quickest entry into the country. You may have to register just to do business in the country, but probably not much more than that. You don't have to worry about structuring all of those things that I talked about with having board members and worrying about the articles of incorporation or the organizational documents reflecting your purposes, having employees. None of that, is really a concern here. Because you're working with a local partner, they're familiar with the environment, so you get to, have great availability of local support and expertise. And this also represents sort of the strongest local empowerment, approach, which is you operate with a local partner, teach them the skills and let them do it, look at the results, and then you can report back to your donors. That's a structure that we've used as well. And it has a lot of things going for it. What it doesn't have going for it, it gets back to the level of control you expect to have over the money that you're sending overseas and the operations that you're running. Is you have to be pretty clear about who this person is, who this organization is that you're working with. And that gets into what we call know your customer issues. It's something if you've worked in the banking industry or already done some overseas operations, sort of KYC, know your customer. This gets back to anti-terrorism, anti-money laundering rules. And it's more than that, though. It's really having a policy and really having a process, and then actually following that and knowing exactly who you're dealing with, and having a risk management strategy to, you can't always know what somebody's going to do. So understanding what could happen if things go wrong. There are also concerns about mission alignment. In the previous two examples, it was either you yourself operating in the country, or two, setting up a company that's at least partially under your control that has your same purposes. With this, you don't know whether your local partner has exactly your same purposes. In fact, usually they won't. So you actually have to look for partners that share your mission. Make sure that it's consistent with your mission, or that the operations that they're going to conduct are consistent with your mission. And there are actually tax reasons for that as well. So we're going to get into that. We talked about the sort of lack of control. You'll have contract terms that you can put into the MOU. As we'll see later, that all depends on whether that contract is enforceable, which isn't always a guarantee when you operate in foreign jurisdictions. And as I said, anti-money laundering, which is what we mean when you see that the abbreviation AML and FCPA. That's the Foreign Corrupt Practices Act. That's the anti-bribery legislation in the United States. These are the things that you need to be aware enough of that you realize that there might be an issue, and you can call an attorney to help you sort through these issues. You're not going to become an expert at anti-money laundering or the Foreign Corrupt Practices Act overnight, or even in a week, or even in a month. So don't worry about that. Become familiar enough with these laws to know when you might run into trouble and when you can seek professional help. Go ahead. The answer is you should try to avoid that situation. You can do it. I mean, it's possible, but you run into issues in that individual is sort of solely in control of that money. Maybe they have a contract with you. Maybe they are a local. You can have contract terms with them. Again, we're going to get to a point where it's a lot harder to chase down a local individual, a natural person, than it is a corporation, and actually get some sort of recourse from them in case that money, something bad, improper happens to that money. If that individual is somebody from the U.S., say, that's there, without some sort of entity or some sort of structure, then you have to wonder sort of how that money got to that person. I guess it could have been wired to their bank account, but they have a bank account here and set up in a foreign country that you have no visibility into. Again, there's a lot of disadvantages to being able to honor your donors' requests, be good stewards of the money that you've been entrusted with, and ultimately, if something happens to that money, there's probably not many opportunities for recourse to get that money back so that you can further your mission. So it's, there's probably ways to do that. It's not ideal, and I'm sure that if you called an attorney and asked, like, how do I do this, that wouldn't be on the list of options. Okay. Actually, I failed to repeat the original question, so sorry I went on a long answer without even saying what the question was. It's basically, if funds are raised in the United States, can they be sent to an individual, or do you have to have some local entity? Okay. Okay, so then the next part of the question is, can the individual be part of a separate organization? I guess I wonder what that means. Is whether you there's something in the law called privity of contract, and it's sort of whether you have your legal relationship with the individual or the organization that you work for. And so if it's with the organization that they work for, I think you're on much better, you're on safer ground. Um, so I guess I would ask what it means, sort of, and think through what it means to be sending the money to an individual versus an organization that individual works for. Typically, when you have bank accounts, you need an organization. An individual might be a signatory on that bank account, but um, there are also U.S. tax implications for that because you know, if you're using it as a vehicle to get money into the country and then you implement your tax exempt purpose, I mean, that's not the safest way to do it. It's not my advice, but it's, you know, you might be doing it. The money might end up being used the correct way. But the IRS is immediately going to flag that transaction and see that it's being sent to an individual, which is for them a non-tax exempt purpose, because all through the history of the Internal Revenue Code and tax exempt organizations, people have tried to figure out ways to use tax exempt organizations to basically enrich themselves. So the IRS is always on the lookout for that. So if you're sending it to a natural person or an individual, and only that, without some sort of organization or structure built around that, not only you're risking the money, the inability to get back the money under local laws, you're risking the IRS flagging you in either an audit or, I guess in a worst case scenario, your tax exempt status itself, it might be in jeopardy because it looks like you're funneling money to some natural person in a foreign jurisdiction. Um, so that's a good time, I guess, when, based on the questions I've been getting, to sort of just give you an overview of the kind of liability that can arise from operating overseas. Remember, there's sort of the liability of the local organization. So they have to comply with local laws. Um, they have employment and labor obligations if you have local staff. There's the liability of the directors and officers serving on the local board. So I talked about this earlier. The board member, the director, is actually a fiduciary of the company he or she is serving on. Now, in the United States, there's a certain amount of immunity for the director as long as they're acting reasonably is provided. My experience in other countries is that concept still exists, but I think the board member, it's much more easy to find a board member liable for improper behavior or loss of funds in a company. So what you'll realize is that there are individuals who are serving on these boards of these local organizations that you may have created that have their own response, their own accountability. So you have these multiple and sort of shifting layers of liability that you all have to worry. At the end of the day, you are trying to protect everybody if you can. You're looking after your good name. You're protecting your donors. You're protecting just the good work that you're doing. You're also protecting the people that you want to participate in your cause, whether that be in the U.S. or locally. So if you have people sort of volunteering as directors on your boards, then you have to realize that they can be held responsible at some point too for any kind of inappropriate behavior. So again, as a parent company, you might be shielded from the subsidiary's actions. So your local entity, if it does something improper, there's a certain amount of protection that you can get from that. However, that decreases with the amount of control that you exert over your local entity, your local organization, the sort of economic entanglement that you have with that organization. If you have lots of contracts, if you're guaranteeing its loans, or its debts or assets, then you get into a situation where you've lost or almost given up that liability shield. And you might be held responsible for the actions of the local organization. And then there's U.S.-based compliance liability. For example, the FCPA violations I talked about earlier, which is the United States anti-bribery law in terms of preventing improper payments with a corrupt intent to foreign officials. And that comes into it comes up more often than you might think if you're working with local government officials trying to get some sort of approval, and you may be asked to give some sort of improper payment that's illegal not only under U.S. but also under local law. So now that we've set up the organization, and you've worked very diligently to pick the best organization, or presence that you can have in the country, and you've got sort of that part of the strategy done. You have to start thinking about how you move money into the country. So you've got this branch office that can own a bank account in the country. You've got a local organization that you've just created that also can own a bank account in the country, or you've got a local partner who has a bank account that you can send the money to. Sometimes just to get the money in the country, you actually have to register with the central bank. Um, the India is particularly notorious. They have something called the FCRA, Foreign Contribution Regulation Act. So they have very stringent requirements for what comes into the country, what money comes into the country. It's not that they don't want money, foreign investment coming into the country, whether it be humanitarian or otherwise. It's just that there are lots of rules to do it, and there's a registration, and they have their own webpage that's in English because I guess they know that this is, they're a country that gets a lot of foreign contributions. So other countries might have the same thing. So you've got to be cognizant of the countries that may require you to take every extra steps to get the money in the country legally. Habitat doesn't do this often, so I don't know much about it, but I imagine sometimes you're transferring goods into country. And that gets tricky because you have the extra issue of import laws and whether or not you have to get these goods locally from some sort of local source first, or try to do that before you can bring in. And it's particularly complicated for electronic equipment and computers. So again, I'm bringing that up and flagging it, but I don't have much experience with that. As just a warning. It is something, though, if you're transferring moving goods into a country, you have to be aware of. So looking a little more closely at anti-terrorism, anti-money laundering, after 9/11, our government issued a couple of executive orders, and ever since then, an entire body of law really has come out. The Patriot Act has been created and developed as a result of that. And because of that, banks, anybody transferring money to a foreign company or a foreign individual, really needs to know what the idea of an SDN is. It's a specially designated national. They have a list of them on the U.S. Department of Treasury website. That's a list that they expect you to check. It's part of kind of a multi-pronged approach that you're going to need. And so to do that, you need a policy. Now, there are policies online. They're not perfect, probably, for your needs. They're usually designed for large banks and financial services organizations. So you're going to find that they're extremely long and arcane sounding, and actually even require you to do stuff that you probably aren't required to do. And so what you'll have to do then is use that model, again, working with your attorney, to sort of pare that down, carve that down to what really is appropriate for your organization. But you really still do need a policy. And the reason policies just in general are important to actually stop and touch on that is having a policy demonstrates one thing, that you've thought about a problem. Two, that you have a process. That policy will have some sort of process built into it, that you have a process that you're following. And that, finally, at the end of the day, if something does go wrong, you have this sort of defense that you took reasonable steps by following this policy that's acknowledged to be the industry standard in terms of whatever it is you're doing. In this particular case, sending money overseas to potential money launderers, potential terrorists. In that policy, you're going to need to do pretty robust screening. There's actually software issued by a number of different companies. The one that Habitat uses is Bridger, I think. It's a LexisNexis product. These can be a little expensive, but I think it's worth it because you actually, it does it very quickly and it keeps a record of what you're doing. So it might be expensive. You can actually just go and manually do it on the Department of Treasury website too. Part of your policy should also include sort of how often you check. You can't just check once, as it turns out, because people kind of come onto the list that weren't on there before. So you can have provided money to somebody and they could have checked out fine, and then 6 months later to a year later, you find out that one of their board members has been flagged because their board membership changed, or that the organization itself has come under scrutiny by the U.S. government. The Foreign Corrupt Practices Act is another body of law. It's been around for a longer period of time. This is, it was mainly created because we have multinational corporations who bribe government officials to get contracts in country. Basically, that's sort of the short story of how that law came about and what they're trying to guard against. However, because of the breadth of the law, it actually might cover your activities if you, again, to set up a registration or asked by the government official to to speed things up, and to get things moving, and and there's a whole checklist and policy that you can develop around that, sort of whether you're paying the individual themselves versus the government entity. One's bad, one's good. Whether or not the payment itself was inappropriate. Is it simply something like, the IRS has expediting fees in case you want to get documents faster. That's not inappropriate. It's not a bribe because you're paying the IRS just to cover their administrative costs. So that's an acceptable payment to a government agency. So you have to be able to determine what's acceptable and what's not. It's not as simple as just anytime you give a government official money, are you violating this act? And again, it could be its own 30-minute to an hour to 2-hour presentation probably, and we can't go deep into it here, but it's something to be just sort of aware of and be able to talk to your attorney about. In addition to those laws, as a charity, as a tax-exempt charity, you're going to have tax compliance issues. And so a couple of the things that you need to worry about is if you're sending money overseas, you're sending it to necessarily an entity that is not recognized by the IRS as 501c3. So you've already triggered something there. Now, is that entity related to your charitable purposes is a question that you have to ask. We talked earlier about how if you're just dealing with a local partner, you have to look at actually what you're doing with that local partner, what that local partner is doing on your behalf. And the reason is because if they're not accomplishing your charitable purpose and then money comes back to you, then that's possibly taxable revenue to you. Even more importantly, in order to maintain your tax-exempt status and be able to give your donors tax receipts, you have to take steps to ensure that the entity that you're giving the money to locally is, has purposes that are consistent with yours, that you have safeguards in the contract with that entity that allow you to ensure that the money continues to be used for 501c3 purposes, tax-exempt purposes. And and if not, then you can take steps to actually claw that money back or get the money back somehow, which is a complicated process we're going to talk about in another slide. So just as a charity, as a U.S. charity, you're actually going to have extra rules to distributing this money overseas. Going back to the branch option, this actually makes things a little easier for you. Again, most control. It's clear that it's your organization operating and using the money. So, that's why the branch suddenly becomes the most, sometimes the more appealing option. So that's the U.S. laws. Guess what? You're in another country, so you also might have to comply with their laws. Are there other registrations required beyond your corporate registration? You have to keep in mind that just to do business in the country, you'll probably have to register with the local government. Just to say, we're a U.S. company, please give us permission to operate in your jurisdiction. It doesn't stop there, though. Usually it doesn't stop there. Sometimes you have to do a registration to undertake certain activities, whether it's fundraising, making loans, if you're in some sort of specialized type of humanitarian operation, if it's medical, construction, there might be additional licensing and registrations that you have to undergo. If you hire employees, you need to understand what the local rules are, even if it's a separate organization. You're old. At some point, even if it's just morally responsible or your reputation is at stake, you do have a stake in understanding whether the employees are being treated correctly um, under both U.S. policy, foreign policy, as well as local laws. Keep in mind that the United States probably has the most employer-friendly laws in the world. So when you get to other countries, you'll find out that there are all sorts of new rules that you probably didn't experience here in the U.S. There are notice requirements before you can terminate them. Even if you have to terminate them for cause, you might have to provide notice, and they may be given the opportunity to submit a memorandum or actually have some sort of informal arbitration. That I know of one country that actually does that, and even if the person is clearly doing wrong, you have to go through a process. Even when you terminate them, you have to know what the requirements are for severance pay or redundancy pay, uh, and they can be extreme. Just once you work a certain amount of time at a company in a foreign country, you may become eligible for a great deal of benefits, more than you'd expect that you have to pay here in the U.S. You're not automatically exempt from taxation locally. You probably have to get a registration for that. You have to probably follow special rules to get that tax exemption. So again, if you're fundraising in the country, you probably have more requirements that you have to follow just to be able to give donations to your, or rather tax receipts to your local donors. Maybe that's not something you're going to do. Maybe you're kind of coming into the country to set up a plan. You're not trying to generate local revenue. But once you start raising money within the country, whether it's through donations or some other kind of revenue generation, then that kicks in, this kind of cascade of regulatory requirements that you're going to have to think about. So not necessarily legal issues, but at the same time, something that is sort of the overarching plan of what that you set up to um, implement a project in a foreign country. There's some monetary issues that you should think about as well. Sometimes the country laws require a certain amount of capital to be put into the country just to set up a local organization there. That's money that you might need to have immediately available. So if you're thinking about like raising money as you go, then you may hit this wall where the government says no. That the first thing that you need to do is deposit a certain amount of money in the bank account before you can even work here. Um, will you need a local bank account? Maybe you won't if you work through a local partner. If you're a branch or a separate, running a separate organization, you'll probably need a local bank account. Finding a reliable bank. Again, this gets back to the know your customer principles and vetting that local bank, looking them up on the internet, seeing how they've been reported in the news, conducting anti-terrorism screening on them. If you have U.S. signatories on these bank accounts, keep in mind that there are U.S. Treasury regulations, something called FBAR. Again, you can Google FBAR and you'll probably find a lot of information about what that is. So U.S. signatories have to disclose the bank accounts that they're signatories on. And not only is it in the tax-exempt organizations, your charity's tax return, the 990, but also that the U.S. person's own tax return as well. There are rules for that. And just in a more general sense, do you have good internal controls and checks and balances? Do you have the proper signing authorities so that if the local organization or person at the local branch wants to cut a check or wire money for more than a certain amount, it has to go through extra review and extra approval. Yes, this slows things down. That's a common objection that we hear because suddenly you have to kind of stop and wait for somebody in Atlanta to tell the person in Madagascar that it's okay to write a check. Does it make things safer? Absolutely. It makes things safer because people have to sort of stop and think about things. So there's always a balance between convenience and security, and you have to again work with your attorney to strike that correct balance, understanding all of these risks. Additional monetary issues, are just arbitrage and foreign exchange fluctuations. So, can you keep the money in there's something called a dollarized account in some countries where you can put your U.S. dollars there and they retain their status as U.S. dollars, and then you can make payments out of that. And what that does is it protects it from any kind of fluctuations in the local currency. That's not always the case. Sometimes you will have to convert your dollars into whatever the local currency is. And so what we've run into is problems where we put the money in the country, we expect the project to be implemented, something happens to the economy of that country, and then suddenly we wanted to build 100 houses, but we ended up only being able to build 50 because the local currency only pays for so much concrete, and so many roofs. Sometimes, beyond currency fluctuations or political risks, where the government suddenly decides it's not going to let certain types of activity occur in its country, and it'll do that without any kind of warning. That occurs as well. So these aren't things that you can prevent. There's something called political risk insurance. There's hedging, it's foreign currency hedging, all of which are things that like giant companies do. It's probably not going to be appropriate for your organization. I mean, and Habitat's pretty big, and it's not even really that appropriate for us. So, having said that, these are things that you need to do. So, what do you do? I mean, it's part of it is when you build out a business plan or a project implementation plan, you carve out a section of that plan just for risk management, and you identify what are your top 3 risks, what are your top 5 risks, what are the things that might cause those risks, what are the things that you can do to reduce those risks. How do you implement the risk mitigation? Who's responsible for that? And then do you have a system for checking up on that? And that's not in the outline. I just kind of quoted it because Habitat right now is going through a lot of what we call enterprise risk management work and trying to look at our own operations and see to what extent we can identify risks and manage those risks. A lot of times people say, lawyers are just trying to eliminate risks. Actually, I think the opposite's true. We understand that you can't eliminate these risks. What you can do is identify them, make an informed decision about whether you accept them or not, and then figure out a plan in case that risk occurs. And that gets us to getting assets back. That's certainly a mitigation step. If something goes wrong, how are you going to get the money that you invested in a particular country back? So the first question is, sort of the saddest option really is, can you repatriate or get funds back at all? Some countries, once you put the money in there, you're really not going to be able to get them back. So what do you do about that? Actually, what you do is you keep the money in the U.S. for as long as you possibly can before you have to deliver it to the local country, and that's how you manage your risk there. Let's just say you can get the money into the country. What kind of payments are permitted? Actually, these are payments back. So Habitat does a lot of lending. So we might, lend money into a country. But what happens if the government decides it doesn't want foreign lenders making loans in the country? It only wants local lenders. There are dividends. There's other kinds of types of returns you can get back from a local entity. Again, you'll have to look at like the characterization of that revenue and whether or not it's unrelated to your tax exempt purpose. Sometimes it is, sometimes it isn't. Will there be local withholding taxes? Sometimes there isn't. Sometimes certain types of repayments, repatriation back to the United States isn't taxable. Sometimes it is. Sometimes there's no way to get around that. Another thing that you have to think about when if you have a plan to get the money back, you have to understand whether or not the local government's going to take some piece of that before it gets back to the United States. You might be tax exempt here, but you're not. Again, you're probably not locally. Hopefully you'll never get into a situation like this, but you may have to try to enforce provisions of a contract in a local jurisdiction. It's going to be very complicated. Again, identifying that this might happen and having a plan for when it happens. That's, we're not telling you to stop doing good work in other countries. Just be aware of these things. So choice of law and forum selection clauses. So you might have heard of those. You might not have. Choice of law means what law you get to use. Let's say you're working in India. You have a choice of U.S. or Indian law. You can put in your contract that the contract has to be governed by U.S. law. That means you can use a U.S. lawyer to interpret it. If a forum selection clause is included, that means you get to try the case that you might have against a local entity in a U.S. court, if that's in your contract. So that sounds great until you realize that many local courts don't recognize U.S. law and don't recognize the judgments that a U.S. court might deliver or award. And so, sort of, then you're left with an unenforceable contract. You know, sometimes they're so offended that you had tried to use exclusively U.S. law that they throw the whole thing out. What do you do then? What about another law? You know, is there another choice of law you can use or another forum you can use? Some countries, African countries um, that were former British colonies, actually have an affinity for UK law. So you could use the UK law and use maybe some sort of arbitration proceeding in London or Dublin or something like that, or not Dublin, but in London. And the you know, that brings us to arbitration, which is a way of resolving disputes not through a court, but through some sort of arbitration or mediation process. These all have different systems. These are things to ask your lawyer about, you know, sort of what the best one might be. UNCITRAL is the United Nations arbitration set of rules. There's the International Chamber of Commerce, and there's quite a few others. The location of that arbitration is actually also important. If, again, going back to our example of the U.S. and India, uh, you're you're forced by the contract terms to do arbitration in the U.S., there might be some sort of resentment or just unwillingness by a local court to enforce whatever comes out of that arbitration proceeding. If, of course, you do it in India, you're worried about transparency issues and local arbitrators being biased against the local you know, organization that you're having a dispute with. Can you move it to Singapore? Can you move it to Hong Kong? There are certain venues in each region, in Europe, in Asia. There are countries that, you know, sort of proclaim themselves as neutral and, you know, and run a business of actually hearing disputes in their courts or in their arbitration forum. So these are also things to do research on and ask your attorney about. At the end of the day, it's if you get into a situation like this, it will be complicated. So the more planning you do is, you know, the better off you're going to be. And at least you're going to go in eyes wide open. You know what the risks are. So that is the end of the official presentation. There might be additional questions. I wanted to end with a few just sort of things that I've experienced, things that you might want to incorporate into your strategy, and just key takeaways. You know, sort of take a lot of care with what option. You know, we had the three options. Take a lot of care with that selection. You know, you might be under pressure by your donors or, you know, or yourself because you want to get started soon to shortcut this process. Well, try not to. I mean, it's something that's going to be hard to undo later on. It's something that will affect, you know, how you can operate, and if something goes wrong, what sort of recourse you can take. So make sure that's the right decision for you. Prioritize good governance and internal controls. These are key steps that you need to take early on in the process. And you know, good governance isn't just do you have control. Good governance is also do you have visibility in what the local organization is doing. Do you visit regularly, or do you telecommute into board meetings? Are you, you know, getting a sufficient amount of reporting from the local organization? Internal controls is much more sort of accounting and audit based, but it's sort of, again, how you set up signatories on checking accounts, who gets to, you know, balance the checkbook versus who gets to write the checks, things like that, that kind of an auditing and an accounting professional will be able to give you a lot of good information on. I talked about the business and risk management plan. You know, include, you know, this isn't just legal issues. It's, you know, including project threatening changes. You know, this can be foreign currency fluctuations or political shifts in the local government, but it's also your compliance issues. You know, those are the things that you can control, is complying with the law, and so you can focus on those at least. As I said earlier, don't send all the money at once if you don't have to, and just having a general exit strategy that takes into account the repatriation rules that I mentioned and the local enforceability issues that I mentioned. And those are really my my key observations about this. And I actually skipped a bullet point, which is using professional employer organizations. This is a way that you can actually have staff locally through local companies. Not every country, in fact, many of the countries that we work in, because they have the greatest need and don't have these business infrastructures, might not have these, but it's an option in some countries. Okay.
The first question is whether you have any thoughts about physically transferring funds into foreign countries.
Yes, it's whether I have thoughts about physically transporting funds. And so, I mean, there are custom laws on both sides, in the U.S. and the local countries. So if you're actually carrying cash, then at some point you have to report it. It looks bad, so because you might be doing it for the right reason, but most people who carry cash, in large quantities across, country borders are doing it for nefarious reasons. So you're immediately calling question yourself. You do have to make a declaration. Cash is very liquid. So how do you keep that cash safe? You're getting into countries where it's secure. Some people would say that you go to the wrong section of any big city in the United States. It's just as dangerous as a foreign country. But you are dealing with a place where language is a barrier. You're not familiar with the territory, or the culture. And in many cases, they are more dangerous and they're less transparent. So how do you protect cash? If you try to deposit that cash into a bank, the bank's going to ask you lots of questions. So I think the only thing that I can think of that is a benefit is if you are having trouble, sort of doing it the normal way. And if that's the case, then that's a whole different discussion. So I'm not sure I consider it a viable option.
The second question is, can you talk a little bit more about
I don't have the actual meaning of the initials like right off the top of my head, but in the question, sorry, was can I talk a little bit more about FBAR and what FBAR is? So years ago, the IRS put on paper laws that required taxpayers in the United States, both natural persons, meaning you and me, like flesh and blood, and also corporations and businesses. They established a requirement that if that company or that person was a signatory on a foreign bank account, then they had to declare it. And then there's some rules for that. It may be that, below a certain level, you don't have to declare it. But if it's above a certain level, you do. And if you're putting enough money in that bank account to probably implement the project that you need to implement in your foreign country, then you're probably going to be subject to FBAR. As a result, you have to make a declaration to the Department of Treasury, and it also has to be declared on the individual's tax return. Great, thank you. Somebody's posted in chat an IRS link to the FBAR, so thank you, whoever that was, and that's exactly where you need to go to find out more. Okay. All right. Thank you. Thanks everyone for taking the time to listen to me, and I wish you the best of luck.